Hey everybody, Matt Johnston here, and we're back talking about independent contractors and some semi-breaking news. Although not unexpected, today the United States Department of Labor announced the withdrawal of the independent contractor rule that had been put together by the Trump administration. The rule was set to take effect back in March, but on March 8th, the Department of Labor put a 60-day hold on the implementation to May 7th, which ironically is 2 days away. So on today and effective tomorrow, the independent contractor rule will not be going into effect. Now, the reasons for that, according to the Department of Labor press release, is that the independent contractor rule that was drafted by the Trump administration was in tension with the Fair Labor Standards Act text and purpose, along with lots of judicial precedent. The rules prioritized two core factors among 5 factors, and that would have, according to the Department of Labor today, would have undermined the long-standing balancing approach of the economic realities test, which is what has been the rule for quite some time. And the rule also would have narrowed certain considerations comprising whether or not an employee is or whether a person is an employee or an independent contractor. So that's what the Department of Labor said. The Secretary of Labor, Marty Walsh, as well as President Biden, have been critical of the Trump administration rule, and so the Department of Labor has revoked it. So what does that mean? Well, from a practical sense, it means that the law that's been in place right now will remain in place. And that law, the analysis that is frequently used, it can best be described in what is referred to as Fact Sheet 13, which I'm going to link to down below. Fact Sheet 13 lists 7 factors that courts have considered relevant when considering whether a person can be classified as an independent contractor. Now, I want to step back and say that as a general rule, the law presumes that a person working for somebody else is an employee, and it takes the employer or the company hiring the person, they have to prove that the person is properly classified as an independent contractor. And that is typically done through what is referred to as the economics reality test, or the economic realities test. And there's multiple different factors, and each circuit court of appeals at the US level and some states all have this slightly different things, but they really boil down to is what is the economic reality of the relationship between the worker and the employing entity. So according to Fact Sheet 13, the 7 principles that should be considered, while not exclusive, generally fall into these categories. 1, the business or the extent to which the services rendered are integral to the principal's business. So are the services part of the principal's core business structure? 2, the permanency of the relationship. 3, the amount of the alleged contractor's investment in facilities and equipment, that is, their own facilities and equipment. 4, the nature and degree of control by the principal. 5, the alleged contractor's opportunities for profit and loss. 6, the amount of initiative, judgment, or foresight in open market competition with others required for the success of the claimed independent contractor. And 7, the degree of independent business organization and operation. All right. So that's a lot of kind of legalese, legal mumbo jumbo, but essentially it boils down to this. How much of a distance economically between the principal, the employing entity, and the contractor or the working entity? How much distance is there, and how much ability does that particular contractor have to make a profit based upon their own initiative? So the economic realities test has been around for quite some time. It's nothing new. And for the time being, that is going to be the rule. Now, you may have heard me talk in other places, and I am going to say it again here. I believe that the Biden administration and Secretary Walsh are going to publish a rule a little bit later this year, which will make a significant change in the economic realities test. And primarily, all of these factors in the economic realities test have been sort of balanced. No one factor is most important. The Supreme Court has been very clear about that. But I do believe that there is going to be a push, and both Secretary Walsh and President Biden and many other leaders in the Biden administration have indicated that they really want to change the rules regarding how employees can be classified as independent contractors or not. And I do believe that the act that they're going to be considering is based upon the ABC test. It was used in the California AB5 legislation that was passed a couple of years ago. And it is the subject of the PRO Act, which is currently making its way through Congress. I don't think the PRO Act is going to make its way into law, largely because I don't think it's going to be able to pass the Senate. But Secretary Walsh, the Department of Labor, and the Wage and Hour Division can pass regulation that interprets the Fair Labor Standards Act and could impose an interpretation that would make it much more difficult to have independent contractors. I realize that this is kind of a little bit of lawyerly doom and gloom, but this is based upon evidence that has been discussed by President Biden. It's based on evidence discussed by Secretary Walsh. And I do believe that the ABC test is likely to be found in our future. The ABC test is much more stringent. It places much more emphasis on things like how much of the worker's contribution goes towards the principal's business operations. So the more closely allied those things are, the more likely it is you're going to find an employment relationship rather than an independent contractor. So the classic example I give is if you're a plumbing business and you hire a plumber as an independent contractor, that's going to be too integral to your business and they would be considered a worker or employee. But if you're a plumber and you hire a web designer, that's not going to be considered, even if that web designer is a true freelancer. That's not part of your core business, and so it could probably pass muster as an independent contractor, but not necessarily. So I want to make that clear. So the ABC test is a little bit more stringent and a little bit more employee friendly. So what should contractors and the businesses that hire them be doing at this stage? This is the time to ensure that the contractors that a business hires are true independent businesses. And we can look both at the contract that's engaged and we can look at the current principles, but also start looking forward into what is likely to come down the pipe next, which is going to be that ABC test. So we can take some time to sort of structure that, figure these things out, so we can see what is going to be a part of or see how the relationship is going to be parsed out between both the employer and the worker. Now, some people might be wondering, am I going to be affected? The whole purpose of AB5, when it was passed in California, part of the express purpose was targeting specific companies, namely Uber, Lyft, DoorDash, businesses that rely heavily upon gig workers, independent contractors, people who work when they want, where they want, how they want. And that is a core function of those companies' business operations. Yeah, except that people don't like it so much, or some people didn't like it so much, particularly elected officials. One could be cynical and say, well, that's because they're not getting the employee withholding tax, but we'll set the cynicism aside for a moment. Those were the intended targets. The problem is the unintended targets, which included things like freelance writers, freelance graphic designers, freelance contractors, writers, people, particularly people who made a conscious choice to pursue a freelance lifestyle, a freelance working environment. So if the Department of Labor institutes the ABC test, this will go beyond what we think of as the gig economy, the gig workers. This could impact directly businesses that hire independent contractors for a particular special project or to expand their workforce for a short period of time when there is a big influx of work. Those kinds of things could very well be impacted. Now, I know this video has run a little bit long, so it's a little bit longer than my normal ones. So please, if you have any questions, if you are a business that employs independent contractors, please click down below and you can get a consultation scheduled with us. In the meantime, be sure you click up here and subscribe to this particular channel so that we can see what's going on. And if you're interested in more content, you can click this little box up here and you can see some of our other videos and see what we've been talking about. In the meantime, I hope everybody is having a good time. Stay safe and go out and watch some live soccer. We'll talk to you later. Bye-bye.